Good evening to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Recently, the Honorable Supreme Court of India, three judges bench, Honorable Justice D.Y. Chandrachud, A.S. Bopanna and J.B. Parthiwala. In the case of Devarakonda, Surya Seshamani versus Care Hospital, right, in civil appeal number 4596 by 2022, held that every death in hospital cannot be amounting to medical negligence. Destiny, a person who is born is destined to die, and normally you get admitted in the hospital only in the later stage. Suppose if you are hale and healthy, there is no necessity for you to go and join yourself in a hospital. No doubt, there is no guarantee that a person will survive even after the admission in the hospital. That's why Section 87, 88 of the Indian Penal Code is given as a general exception. The doctor may try to save you, but there is no guarantee. If you die, you can't hold the doctor responsible as a medical negligence. This is what is held by the Honorable Supreme Court of India in this particular case. Right? Please remember, every death in the hospital will not amount to medical negligence on hypothetical assumption of lack of due medical care and other things. Now, as far as this case is concerned, actually, the allegation of Madam Devarakonda Surya Seshamani is that actually they have admitted she has admitted her husband in the Care Hospital, maybe in Hyderabad. I don't know the place, but she was admitted in the hospital in the casualty ward. And actually, he was vomiting. The casualty ward people, they have admitted him, and actually, after vomiting, they have not taken any care, they have not given any injection, but once again he tried to vomit. He vomited second time also, and he complained of breathlessness. Vomit cheskunnadu, galatla, breathlessness. So actually at this particular time, you see the mental condition of the relatives. They are very much perplexed. So at that time the doctor applied or administered an injection. But what happened? Due to which he has developed cramps, తెలుసు కదా, చేతులంతా ఇదైపోతుంది, తిమ్మిర్లు, and actually he fell unconsciousness. At this stage, the relatives, the wife and others, they were in the casualty ward, so they were suffering a lot. On seeing the sufferance of the patient, now the hospital staff removed them from casualty in an unruly manner, and they have already stated that 70% of the arteries were blocked, right? And actually Devarakonda Surya Seshamani, she was not allowed to go inside. Of course, you may be saying, even in films also you will saying, once the patient goes to the intensive care unit or casualty, okay, they will allow, but they have taken him to ICU where they might have administered some drug, but anyway, by 1:06 a.m., that is in the early hours, 1:06 a.m., he was declared dead. And she felt negligence on the part of the medical hospital, that is Cure Hospital, and she filed a case for compensation of 7 crores for the mental agony. Of course, right from the so-called, since it is 7 crores, State Commission was filed before the State Commission. State Commission did not agree. They stated that actually they tried to adduce the evidence. Now you see the evidence on behalf of the hospital. Hospital said that there is a team of doctors, and Care Hospital is famous for the so-called cardiac people. But the mistake done by the complainant is that she admitted her husband, or when the patient was admitted, the fact of the diabetes was suppressed by the complainant. I don't know why. Normally diabetes nowadays is a common disease, but they have suppressed the fact. So So therefore, when the patient was administered injection for nausea and acidity, there was reaction. ECG was taken and cardiologist was ready, but the patient could not be revived. He could not withstand and he died. So the hospital says there is no negligence on the part of the staff, and the complainant is not able to prove that the death occurred due to the medical negligence. No doubt. That's why in the beginning itself I told you that you can't assure, the doctor cannot assure the life of a person. He tries his best, that's all. That is what is expected from a professional, medical professional. It means he must have the requisite knowledge, he must exhibit the same, and he should take care how to administer the drug. That's all. So life is not in his hands. He must try his best. Here what happened? So here the main point is the court, so NCDRC also agreed with the finding of the state commission, and they said that since the complainant could not prove the case beyond all reasonable doubt, they cannot ask the so-called hospital to pay the compensation. Now Supreme Court also concurred with the NCDRC decision. The appellants are not able to establish any course of conduct suggesting a lack of medical care. That means the doctors tried their best. No clear evidence about the medical negligence. Every death cannot be made medical negligence. Ultimately, the petition or the complaint or the appeal to the Supreme Court has been quashed. So very good judgment, useful for the medical officers. So please read the judgment and enrich your legal knowledge. Thank you very much.